Yes.
May Lordship, I beg to answer item number 3
Yes.
for withdrawal.
3 for withdrawal.
Yes, Lordship. Convicted person is expired.
Okay. Heard, Mr.
DC on behalf of T Tak.
So and so on behalf of so and so submits that he has instructions to withdraw the instant criminal revision petition. Prayer is allowed. The matter is dismissed as withdrawn.
May it please, your Lordship.
Yes.
I appear for the respondent in item number 4. The respondent, the leading counsel for the respondent is out of station.
Which matter?
Subu Kojan, sir's matter.
Item 4.
Item number 4.
Item number 4.
Yes. The leading counsel of the respondent is out of station due to family exigency. Therefore, I humbly pray that the matter may kindly be adjourned for 3 weeks. The learned
You are
counsel for
appealing for
the
the
Petition.
petitioner.
yeah has no objection.
The
my
learned
lord.
counsel, so may I write his name on
The-
behalf of so and so, comma, with the consent of the other side. Pays for adjournment of the matter for 3 weeks. Full stop. The learned counsel appearing for the petitioner doesn't have any objection to the appropriate prayer. Let the matter be listed after 3 weeks.
Lordship, interim order was taken to continue.
Interim order so passed earlier shall continue till the next date of listing.
Okay.
Yeah.
Lordship, item number 10.
Yeah.
Lordship, I on behalf of my senior H. Lampu, Hagi Lampu. Lordship, due to some personal difficulties, he couldn't be appear before this honorable court. So, Lordship, I pray matter may be fixed after 3 weeks.
3 weeks. Okay, Mr. So-and-so, the learned counsel appearing on behalf of Mr. H. Lampu. The learned counsel appearing for the appellant submits that Mr. Lampu is out of station.
Due to some personal difficulties.
Mr. Lampu has some personal difficulties to conduct the case today. Therefore, prays for or some accommodation. Prays for 3 weeks time. Prayer is allowed. Let the matter be listed after 3 weeks.
Obligement.
Item number 1.
Yes.
May, my lord. My lord, by filing this civil revision petition, my lord, the petitioner has challenged the impugned Parwana, my lord, issued on dated 5/3/2026, my lord. My lord, annexure number 1, my lord, page number 10. Page number 10, my lord.
Why are you challenging?
My lord, as because, my lord. Because, my lord knows, my lord, under section 15 subclause 4 of Arunachal Pradesh Civil Code Act and Amendment 2022, my lord. This inter-village customary court cannot assume the role of original jurisdiction. Because, my lord, by bare reading of this very Parvanas, my lord, they are assuming the role of original jurisdiction. Because, my lord, the matter was not tried before the village customary court now, at initial statement. It was not tried. So, my lord, this is my first ground challenge, my lord. And my second ground, my challenge is, my lord, my village, my lord. My village falls under the different circle, my lord. That is Talia circle, my lord. There is this customary code, my lord, assume circle. That is completely different circle, my lord.
But it falls under different circle.
Yes, my lord. And my lord, this customary court, my lord, inter-village customary court, my lord, is usually comprised of the GVs and head numbers of 2 or more villages, which falls within a specific territorial cluster, my lord. So, my lord, in no way, my lord, my villages and this the customary court, my lord, which have issued this impugned, my lord, Parvanas, my lord, this does not have any territorial jurisdiction over my village, my lord. We are completely from different circle, my lord. That I have stated in my affidavit, my lord. Address is also specified in my affidavit, my lord, that I am from Talia circle, my lord. My affidavit is page number 9.
Okay, we'll issue notice.
My lord, this interim order may be stayed, madam, because this hearing is fixed on tomorrow, madam.
Heard, Mr.
El Kurdu, madam.
to the learned counsel appearing for the petitioner. Please stop. The instant civil revision has been filed by the petitioner, assailing the legality and validity of Parvana dated 5/3/2026 issued by the Inter-Village Customary Court under Sium Circle directing the petitioner and his family members to appear before the said Peramba Forum on 14/3/2026 at Namlo Ground, Depot Region at 9 a.m. Next, the Parvana was issued purportedly on the basis of a complaint allegedly filed by the respondent concerning a matrimonial dispute. The learned counsel appearing for the petitioner submits that Inter-Village Customary Court is an appellate court, the party aggrieved by the decision of the Village Customary Court has to appeal before such forum. He submits that in the instant case, no prior village level male Stokeba held earlier, and in the Parvana, all Gaunburas, head Gaunburas appointed as judge are from Sium Circle, whereas none of the petitioner village and even none from the petitioner's village falls under the opposite cycle. He submits that Inter-Village Customary Court under Sium Circle, which has issued the Parvana, has no jurisdiction as the petitioner's village, namely Tachiring village, comes under Taliha Circle. He further submits that Tachiring village, the native village of the petitioner, has its own Gaunbura. Therefore, he submits the issuance of the Parvana is illegal, arbitrary, and without any jurisdiction. Full stop. In view of the aforesaid submissions, he submits that the impugned Parvana dated 5/3/2026 should be stayed. Let notice be issued to respondent numbers 1 to the sole respondent by speed post as well as on usual course within a period of returnable within 4 weeks within a period of within a period of 3 days. It's supposed to. In the meantime, the impugn Parvana dated 5/3/2026 shall be stayed until further orders.
Deeply aware.
Matter number 2.
Yeah, Lordship, please. Lordship, this is a criminal joint application filed under the section 528 of BNSS for causing and setting aside the FIR dated 01/05/2025 and charge sheet number 04/25 dated 22/05/2025 corresponding to PS Tato PS case number 03.
What happened? What is the offense?
Offense. Lordship, issue is that petitioner number two and petitioner number 3 was exchanging message on WhatsApp, wherein petitioner number 3 used slang words and defaming the Adi community, more particularly Bokar, Lordship. FIR is at page 21, Lordship.
Page 21.
Yes, Lordship.
Yes.
May I read the FIR, Lordship?
Petitioner, informant is who is the informant?
Informant is, Lordship, petitioner number 1, Lordship.
No, I understand. I mean, on behalf of Adi students.
Yes, Lordship. Petitioner number 1 is Adi's General Secretary, Adisu Siyomi District Unit, Lordship. Somehow the message conversation between petitioner number 2 is victim, Lordship, and petitioner number 3 is accused, Lordship.
Petitioner number 2 is Adi from Adi community, no?
Yes, Lordship.
He is from Adi community.
Yes, Lordship.
Petitioner number 3,
Petitioner number 3 also Adi community, Lordship.
Adi community. Then how it is, I mean, defaming or
No, Lordship, page number 3 is Galo community.
Huh?
It's from a different community, Galo community, Lordship.
3 is from Galo community.
Yes, Lordship.
And message was sent to whom?
Lordship, there's 2 and 3, Lordship. They both are exchanging messages through WhatsApp, Lordship. And Lordship,
1 and 2.
yes, 2 and 3, Lordship.
2
1
and
is
3.
the complainant. Yes,
2 is from 2 and 3 from different community.
yes, Lordship, different
And
community.
3 has sent some
Yes,
messages,
Lordship. They,
messages against Adi
Yes.
community.
yes, Lordship. And after that, they have mutually settled, Lordship, and apology letter also been, Lordship. They-
So we'll close this. I mean, there's
Yes,
nothing.
no, there is nothing because only compoundable offense is this one Lordship. 196 only, Lordship. Both are compoundable offense.
Okay, we'll close this then.
Yes, Lordship.
Miriam, see, it's compromise petition. Same will be there. So you just take their names and we'll pass the order.
Yes, Lordship. At last, Lordship.
Biblio.
Matter number 5.
Lordship, here, report from learned trial court was sought and scan copies of register. This was regarding the
Oh,
before.
correct. What has happened to that? Mr. Ete.
Yeah, I've gone through the record, my lord.
Oh,
My lord, so far as the record is concerned, in fact, my lord,
report has
Yes.
come.
yes, my lord.
What is the report?
My lord, on second, my lord, in fact, the date which has been mentioned in the order itself is wrong. Because, my lord, so far as the report is concerned, the concerned magistrate, special court has stated that the charge sheet was received on second itself by the GR, and on the same day it was forwarded to the his office, and it was received by the office staff. So, my lord, the date of the receipt of the charge sheet would be the 3rd, when it was first put up before the magistrate.
So he's
He is entitled then, my lord.
entitled to,
Yes, my lord. Because his application was filed on second, my lord. And it was no doubt received on second itself, but it was not received by the magistrate, my lord.
it was not put up before the meeting.
Yes, my lord.
So he has specifically stated in his report.
Yes, my lord.
Let's see the what.
Yes, my lord. Report is there in the record, my lord. It's plague mark, my lord.
Okay.
Or in the main file, my lord. Plague mark is in the main file, my lord.
Main page, okay.
Yes, my lord. They have marked, my lord, the highlighted, my lord, but dark only in the register scan copy, my lord. The name, accused name.
So it was on 2/12/25.
Yes, my lord.
Time is not there.
Yes, time is not the time they have not recorded, my lord, admittedly.
Time they have not recorded.
Yes, my lord.
And this is the register of filing of the bail application,
Yes, on second itself, my lord.
second itself.
But it is a fact that, my lord, it was received by the OPC staff, not by the magistrate himself.
So then we pass the order.
Yes, madam. Yes, madam.
We'll pass the order in the chamber.
It is deemed to be filed on, my lord, third only. Then.
So, I mean, since there is no signature of receipt
Yes,
or seen by the
magistrate.
I mean, district court.
Yes, madam. Special.
So it will be held that he has, I mean, charge sheet is filed, I mean, he has taken cognizance of the charge sheet on third.
Yes, madam. When it was first time, it was seen by the
When is
magistrate.
the 60 days? When is the 60 days?
180 days, my lord, actually.
180 days?
180 days was complete on 27/11/2025.
Huh?
27th November 2025.
My lord, earlier he was entitled and it was continued, but he has not availed it. But after a lapse of 3-4 days, he has filed an application on second. And prior to that, also the charge sheet was not filed. Because, my lord, this is an NDPS case wherein section 37A applies. The offense, the total, the mandatory statutory period would be 180 days.
So 180 days completed on when?
27th till November
27,
2025.
27 November.
25.
25. And, my lord, one more fact, there is no any application for extension of that period, my lord, because it can be extended to 1 year, my lord.
No extension.
Yes, no extension application was pending.
No extension application.
Yes, my lord. And he availed it on second itself, my lord.
Secondly.
2nd of December, my lord.
No, I mean, tell me one thing.
Yes, my lord.
His mandatory of period is over on 27th.
Yes, my lord.
Then if charge sheet is filed,
Prior to that,
the charge sheet was filed when?
charge sheet was filed on, my lord. Now the
Second.
third, my lord, as per this.
Correct,
Yes.
Now it is, but if it is filed on second also,
Yes, my lord.
then why he was not granted the default bill?
My lord, that is the issue. Before that also, my lord, here, my lord, the infirmity is there. My lord the order itself is wrong, my lord. That's what I'm trying to, my lord, point out. In the order, the special PP has made a submission that if charge sheet was filed on 1, my lord,
Oh.
first.
If it is filed on first also, he is liable to bail.
No, my lord, or if he is filed on second, if suppose, my lord, hypothetically, if it was filed on 1, charge sheet was filed on 1, then his default bail will be extinguished because he has to file prior to the file.
Filing.
Yes, yes, ma'am. Yes,
I mean,
charge sheet.
filing of the charge sheet.
Yes, ma'am.
Bail he did not file, that is why it has gone to third.
Yes, my lord. Because even if prior, after, my lord, expiry of 180 days, if,
No, if it is expired, I mean, 1 year back also 180 days. but
Yes,
if you
ma'am.
do not file bail.
Yes.
Then you don't get bail.
yes, absolutely, my lord. Yes,
So
he has
when
to
you-
pardon.
When you file the bail, then only he will be liable. He will
Absolutely,
be having the right to bail.
absolutely.
But he has filed a bail application
After expiry of
after expiry of the period.
4 or 5 days,
5 days.
Yes, Lord.
And by that time, the charge sheet was filed.
Yes, Lordship.
file, yes, madam. But not in accordance with that this judgment held by our
Correct.
ordinate bench.
Correct.
So if it is on third, then he avail it on second itself. So once he avail it, even if charge sheet is filed, even appeal is filed, it will continue, my lord. It will not, it will continue, his default bail will be continue. my lord. And my lord,
Because he filed on second and as per the High Court's judgment,
yes, my lord.
the charge sheet has to be termed to be deemed to have been filed on third.
Yes, my lord.
So that's why On second, he is liable to get the.
Yes, my lord. And if, my lord, if, so interestingly, if the charge sheet and his application was filed on second itself, then time would be very vital, my lord. Who filed first?
Correct, the time is not there.
Yes, my lord.
Lordship, that is why on previous occasion, I also called for the record of the one register of the filing section.
But that is not there, the time is not there.
Time is not there.
Mention the time. That is what I want to bring to the knowledge of this court that
But the time has been
Yes, yes.
mentioned.
yes, the time has not been mentioned. Lordship.
What my lord, what my humble prayer would be, my lord, when my lord will definitely he's entitled for the this default bail, my lord, may kindly highlight this because the no court is trial court is, my lord, this aware of this judgment actually, my lord.
So this judgment should be circulated.
Yes, my lord.
So I will pass a direction that this judgment of this
Yes,
Guwahati High Court should be circulated.
to all over state of AP, my lord.
to
Lordship, also the-
state of-
Yes,
all judicial, to all the courts.
yes, my lord.
Also the direction that in a filing section, they ought to mention the time.
No, no,
That is the official procedure. I
that
mean,
cannot be interpreted.
Once the judgment is passed, judgment is circulated, then they'll get to know about this.
Everything will be
What is
clear
to
then.
be maintained.
Yes, ma'am. That may be done, my lord.
That I can pass an order
Yes, ma'am.
stating that this should be circulated.
Yes, madam.
Should be circulated.
Absolutely.
That will be done by the registry.
Yes, madam. Registry will circulate the judgment copy to all the concerned judges, madam. Yes.
Okay, I will pass the order.
Okay, ma'am. Obliged, ma'am.
Will allow him.
Yes, ma'am. Law is in
In his
favor.
favor.
Yes,
He-
ma'am.
he's-
What to do, madam?
He just escaped somehow. Huh?
Yes.
You see those bars, na, like? Then bars, then the gymnasts go. Somehow they scrap through.
Yes.
The small 1 feet height bars. Then all those gymnasts, they go,
Even-
somehow they manage to pass through his pass through.
Yes, madam. And the police, even they are not aware of it. Otherwise, they could have take signature from the magistrate ways and when the charge sheet was produced.
So this judgment should be, I mean, is very relevant. It
Yes.
should be circulated.
Yes, ma'am.
That direction should be given to the.
Yes, ma'am.
So that they can maintain this thing.
Yes, ma'am.
Confusion doesn't arise there.
Yes, ma'am. Deeply obliged, ma'am.
Item number 6.
May I please, Your Lord, please?
Yes.
This is a regular bail application.
Hmm.
If this was arrested. If it was arrested in connection with Niti Bihar police station case, we'll find the FIR at page number 20.
What is the allegation?
Allegation against her, against the accused is that she had set the house on fire and caused the death
One
of-
second, 1 second. What?
Allegation is that he had set the house on fire and caused the
They
death of
set the house on fire.
fire.
Whose house?
Her house.
Her own house.
Yes, her own house and caused the death of her husband and mother-in-law.
Caused the death of her husband and mother-in-law
Yes,
because of the fire.
because of the fire. This is only a mere allegation.
Okay. What is the correct fact?
The correct fact, Your Lordship, on the day of night, the deceased husband, he returned home lately in a fully drunken state
Hmm.
and started an argument with the accused, calling her whore and accusing of her, accusing her,
Accused is the wife.
yes,
Yes.
accusing her of sleeping with someone else. Because, Your Lordship, on the last night, the wife, the accused person, did not return home. For that, and he was continuously arguing, mentally torturing the accused person and asking her to leave the house. So the accused person has left the house along with all her belongings. So in the meanwhile, when the
She
accused
went out on
went
the,
out,
on the,
she had left the house.
she left the house on the previous night.
Yes, previous night she did not return the house. On the day of occurrence, on the night of occurrence, when the accused returned the home,
Then he found her.
yes,
Hmm.
found her
Then they had the altercation.
altercation, whole altercation.
Hmm.
So during the altercation, the accused person constantly, he was repeatedly asking the accused person to leave the house. So the accused left the house with all her belongings.
Then during the night when the fire happened.
Yes.
Okay.
At around 4 a.m., the accused person received a call from the relative that the house has burned down. So when he reached the spot,
When she
when she reached the place of occurrence, he found the house was already burned down
and
No neighbors are there.
neighbors were there.
Hmm.
Neighbors were there. She found the husband and the mother-in-law already died because of burned up. So immediately the complainant here is the biological brother of the deceased. So from the very inception, the complainant never accepted the accused person as his sister-in-law because of our previous background, and the relationship with the deceased was also not smooth. The accused person has never smooth relationship with the accused with the family member of the deceased. Therefore, Your Lordship, on mere suspicious, the FIR was lodged. FIR is, Your Lordship, as per the FIR, it is stated that by the complainant that the accused person has set the house on fire by locking the deceased inside the house. But Your Lordship, during the examination, the complainant, the defect of complainant.
I mean, now what is the state of that this investigation?
Evidence.
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 The matter is pending.
Pending.
I mean, he's in jail for how many months?
For almost 1 month. For 1 year. 1 year. He was arrested on 24/3/2025.
And your bail was rejected by the court, lower court.
Lower court.
When?
Only on the ground that the accused may influence the evidence. Only on that.
How many evidence completed now?
Two evidence completed.
Who are they?
The complainant, the defect of complainant and
Complainant,
the neighbor.
complainant and neighbors. And what about this accused? No, not yet. Oh, because it's a trial. Okay.
Yes. And Your Lordship,
Complainant and neighbors.
and the witnesses has completely stated they have not seen the accused person setting the house on fire, as well as they have not seen the accused person locking the disease inside the house. Only on the mere suspicious, because the accused and previously the accused and the disease, there on 2 occasions there was major altercation between them.
My first Lordship, in this matter, earlier, Lordship, this accused was granted bail, default bail, Lordship, on 25/6, Lordship. I flagged on 25/6/2025.
25/6/2025.
But due to the non-execution of the Lordship bail, Lordship, he was taken into custody again in the remand, Lordship.
But she was not complying with what?
She is not executed bail, Lordship. Bail granted on, Lordship, default bail granted on 25/6/2025.
She did not go to she didn't, nobody was there to take bail for her.
Yes, Your Lordship, she was not being represented by any advocate during the time when she was granted with default bail. Subsequently, bail application was filed, but the learned trial court rejected the bail application merely on the ground that she might influence the witnesses. Page number 55 of my bail petition here.
1 second. So your bail was rejected on 24/9.
23/7/2025. 23/7/2025.
No, 24/9/2025.
Page number 60.
Oh, yes, Your Lord. In the chart sheet.
24/9. Who is Ruhitai? Ruhitachu is the complainant. But who is Ruhitai? But Ruhitai says that I have filed the FIR. And Ruhitachu is the sister.
Ruhita is the biological brother of the.
Ruhita is the brother. And Ruhitachi is the sister.
Biological sister.
Only 2 witnesses still now.
Yes, Lordship, but there is no fault on the part of the Lordship since trial already commenced. Since trial is already commenced, Lordship, there is no delay in the part of the trial, Lordship.
Yeah, correct. But like only 2 has been examined.
Yes, Lordship.
2 witnesses have been examined. But there is an allegation that you have planned it.
No, Your Lordship.
And you have taken all your personal staff's certificates, etc., from the house and kept it in your shop. Why?
Yes, Your Lordship, during the night, Your Lordship, the accused person was repeatedly asking me to leave the house. The accused was calling me for accusing me of sleeping with another man because, Your Lordship, previously night I did not return the home. After 1 day, I returned home. Therefore, Your Lordship, the accused person was mad at me. He was without any valid reason. He was continuously arguing with me, mentally torturing me. Therefore, Your Lordship, I was compelled to leave the house with all my belongings.
Earlier also there was a death threat of their consequences, Lordship, threatening the disease, Lordship, of their consequences in the earlier also before this unfortunate incident, Lordship.
Who that accused?
Yes, Lordship.
Because of that, Your Lordship, now the complainant is suspecting that the accused person had set the house on fire. The relationship was never been smooth. And also, Your Lordship, in my petition, I had stated that, Your Lordship, at the time when the accused person reached the place of occurrence, the police has arrested him without giving him without communicating any ground of arrest.
Yeah, those things are different. Yeah, those things are, they're separate things.
And while rejecting the bail application, Lordship, but the learned track rightly observed that all the witnesses are their relatives, so there is a chances of, Lordship, influences, Lordship. Since Lordship is aware of the X versus state of Rajasthan Lordship, wherein the
Hmm?
X versus state of Rajasthan Lordship, wherein the Honorable Supreme Court of the Beauty, once the trial is commenced, it should be allowed to end it finally in Lordship.
And trial is going on a right speed.
Yes, Lordship.
It's not delayed. You only
Your Lordship, here, your Lordship, this person has falsely implicated, so there is
the
no.
trial will decide. The trial will decide. I mean, it's a allegation is very serious.
Your Lordship, with any condition, your Lordship, you may be related to granted bail.
Not at this stage.
Your Lordship, I would like to rely on the citation.
See, I mean, what Supreme Court has said. Ordinarily, in serious offenses like rape, murder, dacoity, etc., once trial commences, the prosecution starts examining its witnesses. The court, be it trial court or high court, should be loath in entertaining bail application of the accused. Very clearly they have stated.
Yes.
This is passed by Justice Division Bench of the Honorable Supreme Court.
So, your Lordship, there is no any implementation method against the accused person. If
See, very detailedly, sir, over a period of time, we have noticed two things. Either bail is granted after charge is framed and just before the victim is to be examined by the prosecution before the trial court, or bail is granted once the recording of the oral evidence of the victim is complete. By looking into some discrepancies here or there in the deposition and thereby testing the credibility of the victim. We are of the view that aforesaid is not correct practice that the courts below should adopt. Once trial commences, it should be allowed to reach to its final conclusion, which may either result in conviction of the accused or acquittal of the accused. The moment High Court exercises its discretion in favor of the accused and orders release of the accused on bail by looking into deposition of the victim, it will have its own impact on the pending trial. When it comes to appreciating the oral evidence of the victim, it is only in the event if the trial gets unduly delayed, and that too for no fault on the part of the accused, the court may be justified in ordering his release on bail on the ground that right of the accused have speedy trial has been infringed. Yes, the Supreme Court has stated he has given a judgment which is very relevant.
the Supreme Court, your Lordship, in a very recent statement, your Lordship, lay down certain guidelines.
No, so this court has to see, because in this case there is a serious allegations against you, and you were not found in the place when the incident occurred, whatever may be the reason, and there was an allegation that you have taken out all your goods and left after burning the house. The allegations has to be. This court cannot opine on the merit of the case, but thing is that there are serious allegations, and trial has started, and trial is going on. Trial is not delayed. When was the this thing filed? This incident happened.
Incident happened in the month of Lordship, March.
March
2025 Lordship.
March 2025. So it is running in a fairly good speed. There is no delay. What do you want to show from here? 253.
Page number 21.
Now, this is something. This is with we hold that in cases where police are already possessed of documentary material and trial hasn't started in this case. There are section 47, 50 notice not properly served. Those things were involved in this case. This is not relevant to this. It will be difficult to resist.
Kindly, your Lordship, with any.
No. No, it will be difficult. I mean, on the face of this judgment, I mean, then it will be difficult. How can we deny what Supreme Court has laid down? Right, heard Mr.
Income tax.
Learned Counsel appealing to the accused applicant. Also heard Mr. B. Louis, the learned PP for the state. This is an application, right? Application so and so. The gist of the case involved in this case, gist of the case involved is that an FIR dated 24/3/2025 was lodged before the Niti Bihar police station by one Sri Ruhi Tai, alleging inter alia, that on 24th March 2025 at around 3:30 a.m., the alleged the accused applicant, namely Srimati Tas Nako and her husband had a fight on some personal family matter. Semicolon, that the fight and argument between them continued till about 3:30 a.m. Semicolon, that thereafter the alleged accused thereafter the accused applicant allegedly burned the house wherein her husband and her mother-in-law was residing. Semicolon, that the accused applicant had forcibly snatched the cell phone of her mother-in-law and thereafter locking both her husband and mother-in-law inside the house, set the house on fire. Next para, on receipt of the FIR, the police registered Niti Bihar or Nita. It is Nita or Niti? Niti, na? Niti Bihar PS case number 09/2025 under the aforementioned sections. After the completion of the investigation, the IO has filed charge sheet number 19/2025. There are 25, and thereafter charges against the petitioner, accused applicant, was framed under section 326 in bracket small g /103 of BNS, white order dated 23/7/2025. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant had filed a bail application before the learned session judge, UPA, Arunachal Pradesh. However, the same was rejected by the aforesaid court on 24/9/2025. 24/9/2025. The learned counsel submits that the case has been registered against the accused applicant merely on suspicion, as the accused applicant and her husband were not having a good relationship, and she was being tortured by the husband on many occasions after being drunk, after getting drunk. Full stop. He further submits that on the fateful night also there was a quarrel between the husband and wife involving mother-in-law also, wherein she was asked to go out of the house, and therefore she went went out of the house taking her belongings. Full stop. He submits that thereafter what exactly happened she is totally unaware of, and she had been implicated in the instant case falsely by the family members of the deceased husband merely on suspicion, as they were not having a cordial relationship. Which post. In view, he further submits that the accused applicant is already in jail for last 1 year, and two of the witnesses have two of the prosecution witnesses have already been examined. Also, in view of the aforesaid, he submits that the accused applicant should be granted bail at this stage. Full stop. The trial court record in the instant case has been received, which is perused by this court. Full stop. The learned public prosecutor, on the other hand, submits that this is not submits that the case relates to a heinous crime of killing two persons, and since the trial is going on in a relatively good speed, and two of the prosecution witnesses have already been examined, this is not a stage wherein this court should allow the accused applicant to go on bail. Full stop. In this connection, the learned PP has relied on the case of X dash appellant versus State of Rajasthan and another, reported in 2024 Supreme in bracket SC 1106, wherein the Honorable Supreme Court has held that once the trial starts, the trial should be allowed to come to a logical end, and during that time the bail should not be granted wherein the offense alleged is of a heinous crime. Full stop. Next paragraph. This court has heard the submissions made by the counsel appearing for the respective parties, and taking into account the stage of the trial, which seems to be going in a reasonable speed and expected to be completed within a short period of time. And also taking into the observation made by the Honorable Supreme Court in the aforesaid case of X, this appellant Supra, is of the considered view that this is not a stage wherein the accused applicant should be granted bail. In this connection, the following paragraphs being relevant are extracted here in below. 14, 15, and 16. You just take it from here. Next paragraph. In view of the aforesaid discussions and taking into account of the observations made by the Honorable Supreme Court, the instant bail petition is disposed of as rejected.
Matter number 7.
Your Lordship, in this matter, I have been informed that the case has already been charge sheeted. Therefore, if TCR may be called for Your Lordship.
You go and appear before this, why TCR is still called?
Your Honor,
You go and appear, it's a criminal petition.
Petition.
yes, Your Honor.
Oh, criminal petition, for what?
So quashing, Your Honor.
Causing
Honor,
of
we
the
have-
FIR.
Yes, Your Honor. We recently we have been appointed this case, Your Honor. Earlier, this other counsel were appearing for this case. So after filing Wakalatnama, this is the first time we are appearing today.
Huh.
And then information has been received that the charge sheet has been already filed. So therefore, meantime,
Okay, then you heard Mr. So-and-so, the
Your
other
Lordship,
counsel.
if I may suggest, Your Lordship. Lordship, since the charge sheet has been filed and we are not aware of what section they have been charge sheeted upon, Your Lordship. Also, the charge sheet has to be challenged. Subsequent.
How that they will do, I mean, what do you want to do?
so meantime, we'll file additional affidavit to
Let
prevent.
them bring the additional affidavit. Which is on record. But you'll have to challenge that. How will you challenge that?
For that, like, we'll make a modification in the petition.
Then you have to file an IA for that.
Yes, Your Honor.
If they can withdraw with liberty.
Or you can take this, where you withdraw this and file a fresh.
In that case, I will seek instruction, and then in that case, I will seek instruction for withdrawal, and then
You withdraw this, that will be better. Otherwise, it will be haphazard. I mean, additional affidavit, then IA, then IA has to be allowed. Then you'll have to go for modification of this petition. It will be a process that has to be followed. It's better you withdraw it.
Your Lordship, in that case, I'll seek instruction from my senior, and then
You speak to him and come back after some time.
that will.
After some time means he'll
Yeah,
come.
Lordship, I appear on behalf of the respondent number 2, and I've filed the wakalatnama.
Okay, then let him take instructions. I mean, you can come back in 5 minutes.
Yes, Your Honor.
Just speak to him and come back.
Yes, Your Lordship.
Our time being passing it over.
Oh, okay.
Make it fast.
Item number 8.
Lordship, here Lordship, the investigation completed Lordship and it has been submitted as FR Lordship.
FR is
Yes, Lordship.
But the petitioner is not there.
Yes, Lordship, but the petitioner is not available.
MS B Sharma, somebody. You could have closed this matter then.
Oh, yes, Lordship, because otherwise Lordship is already this FR is submitted as FR Lordship. Then they have only challenged the FIR Lordship.
But no one is there.
Then the next date, I'll produce this.
So we'll pass it over.
Yes, Lordship.
None appeared for the petitioner when the matter was called for. G Tae, you know anybody G Tae?
Yes, Lordship.
We need to find out.
But Lordship, he is practicing here, Lordship. But this earlier.
He can take instructions probably. We can close it.
Today, Lordship, he is not available, Lordship. I didn't see him today, Lordship.
Okay, no, none. But we could have closed this matter. Unnecessarily it will be pending.
Yes, Lordship, that is there, Lordship. If Lordship thinks that today Lordship petitioner side not available, next date may be given. Otherwise,
okay, we'll pass it over then. None appeared for the petitioner when the matter was called for. Though MSL Hage, the APP is present. In the interest of justice, let the matter be listed in the next.
Yes, Lordship. My supply.
Yes.
Lordship, I have instruction to withdraw this.
You withdraw this, it will be better. Next, give me this. Heard Mr. So-and-so, the learned counsel appearing for the petitioner. Also heard MS.
P. Mubang.
P. So-and-so, yeah, for respondent number
Number
2.
2. Yes, Lordship. Respondent number 2.
Respondent number 2 and MS TGD, the learned APP for S2. The learned counsel appearing for the accused appearing for the petitioner submits that he has instructions to withdraw the instant case as charge sheet in the instant matter has already been filed by the investigating officer. In view of the aforesaid submission, the instant petition is dismissed as withdrawn.
And the liberty to file.
You have the liberty. We were dismissed as withdrawn with the liberty to file FS.
Highly obliged.
Matter number 9.
Continue. That will anybody. The head judgment release quotation. Production is bonus. Yes, what is it all about?
This is a statutory appeal against the conviction laws. It is the conviction against POCSO under section 8.
So we'll have to issue notice on this.
And Lordship, with regard to this, before this.
There is a delay.
Delay, that may be condoned now.
No, this POCSO matter, I mean, how many days?
30
days.
30 days.
30 days.
But I mean, we'll have to allow the other persons to be there.
Yes.
We'll have
Yes.
to issue notice. We can't delay, I mean.
Because for that, I have application for the suspension of the sentence. And so on.
Correct. So that has to be, that all these things has.
That may not be, that is not listed by that. Yes, sir.
What do you say? I mean, delay part,
That-
what is, delay will condone that.
It's statutory.
On
that
only about
condone.
32 days, Lordship. I have no objection.
Delay will
That
condone.
will
Yes,
condone
yes.
notice issued to the party as per the relevant rule. Ground is written at section 5. Since it is a level class people, if you object for party, if you could not manage.
Okay, but I'm right. Heard Mr.
Pitapa.
Pitapa, the Lord Counsel appearing for the petitioner. Also heard Mr. B. Louis, learned PP for the state. The instant I has been filed under section 5 of the Limitation Act 1963 for condemnation of delay of 32 days in preferring the connected criminal appeal against the judgment dated 9/12/2025 and sentence order dated 9/1/2025 passed by the learned special judge in bracket POCSO, Khonsa division, Tirap. Full stop. The learned counsel of the learned counsel for the petition for the applicant submits the delay occurred. The delay of 30 days occurred in filing the connected appeal only due to the object property of the appellant and his wife. Wife. Therefore, he praised that the delay of 32 days in filing this statutory appeal may be condoned. Full stop. Mr. D. Loy, the learned public prosecutor, doesn't have any objection in condemning the delay of 32 days. This court has also perused the explanation given at paragraph 5 of the instant application and being satisfied with the explanation that has been given. The delay of 32 days is condoned. Full stop. In view of the condoned. Full stop. This extra IA is disposed of. Then in IA for suspending this thing, we write
IA for suspension.
okay, this is numbered, no?
But it was not listed.
Not listed.
Hmm?
Then on.
I was not listed.
I is not listed.
Only
this one.
this condemnation, Lordship.
Okay, then This one, criminal appeal, I have to pass an order.
Yes.
Then let the, I mean, in view of the condemnation of the, in view of the disposal of the connected IA for condemnation of delay, by condoning, by condoning the delay, let notice be issued in the connecting, in the instant appeal to the respondent number 2 by through to the respondent number 2 through the registry as per the prevailing notification of the Guwahati High Court. Full stop. Notice to respondent number 1 is dispensed with as learned if learned PT has entered his appearance in the matter. Let the matter be listed after
Along with the pending IA for suspension, that may be
Uh,
listed together.
let the matter be listed after 4 weeks.
After 4
After 4 weeks, along with the
Pending IA.
pending IA for suspension of the impugned judgment and sentence order dated
19th.
9 to 12.
19 December.
Huh?
19 December.
19 December,
It's 9 December
9 December 2025.
25.
2025. Full stop.
Different.
Pronouncement of judgment, item number 11, criminal revision petition 33 of 25.
The instant criminal revision petition is dismissed. It was heard, Ginny was there, Ginny was there. It was heard yesterday, so we have delivered the judgment.
Yes.
Plus intimate, yes, we have delivered the judgment, the petition is dismissed.
Different.